Mediation is often promoted as an ideal way to resolve disputes outside of court, but it has significant drawbacks that can leave parties vulnerable and dissatisfied. Understanding these limitations is crucial before choosing this path to conflict resolution. Mediation is a process where two parties in a legal dispute meet to resolve their disagreement with the help of a neutral third party called a mediator. Unlike court proceedings, the parties themselves are responsible for reaching a solution, with the mediator simply facilitating communication rather than making decisions. The process typically involves preliminary meetings, joint sessions, individual consultations, and ideally concludes with a settlement agreement. One of the primary disadvantages of mediation is the lack of formal rules and procedures. Without the structured framework of a courtroom, less prepared parties may find themselves at a significant disadvantage. The absence of formal discovery processes means that crucial evidence might remain hidden, making it difficult to establish the complete truth of a situation. Power imbalances between parties represent another serious concern. In traditional litigation, legal safeguards help ensure fairness. Mediation lacks these protective mechanisms, potentially allowing more aggressive, better-informed, or resource-rich parties to pressure vulnerable individuals into unfavorable settlements. A mediator has limited ability to correct these imbalances compared to a judge in court. The non-binding nature of mediation creates additional problems. Even after investing significant time and money in the process, parties may fail to reach an agreement. Worse still, one party might agree to terms during mediation but later refuse to honor them, necessitating litigation anyway. This effectively negates the time and cost benefits that mediation was supposed to provide. Mediation also lacks a formal discovery phase. In court proceedings, attorneys can compel the production of documents, take depositions, and gather evidence systematically. Without these tools, parties in mediation may struggle to obtain the information necessary to support their claims or make informed decisions about settlement offers. Some disputes are fundamentally unsuitable for mediation. Cases involving criminal activity or domestic abuse require formal legal intervention to protect public safety. Matters needing urgent injunctive relief cannot wait for the mediation process. Disputes where establishing legal precedent is important are better addressed through the court system. Situations demanding public accountability also benefit from the transparency of formal legal proceedings. Even when mediation is appropriate, poor execution can derail the process. Common mistakes include entering mediation unprepared, without clear understanding of legal rights or desired outcomes. Overconfidence and inflexibility often lead to breakdowns in negotiation. Some parties use mediation merely as a delay tactic with no genuine intention to compromise. Unchecked emotions, particularly in family or business disputes, can transform potentially productive sessions into unproductive confrontations. The absence of constitutional protections in mediation presents another significant drawback. Courts operate under established rules that protect individual rights, while mediation offers no such guarantees. Additionally, mediation cannot establish legal precedent, which may be important for novel or significant legal issues. Perhaps most concerning is the risk that unsuccessful mediation can actually harm subsequent legal proceedings. When mediation fails, parties may have already revealed their best evidence or strategy, giving opponents valuable insight for trial preparation. This strategic disadvantage can be difficult to overcome. Before choosing mediation, carefully weigh these disadvantages against potential benefits. Consider the nature of your dispute, the relationship between parties, and whether formal legal protections are necessary for your situation. In many cases, consulting with an experienced attorney before entering mediation can help you determine if this approach aligns with your legal interests or if traditional litigation would better serve your needs. Understanding when to avoid mediation is as important as knowing when to pursue it. By recognizing its limitations, you can make an informed decision about the most effective path to resolving your legal dispute.